Have you ever stopped to think about what would happen to your family if something happened to you tomorrow? Maybe you've put off making a plan, telling yourself you'll get to it later, maybe some other day. But there's always that small worry in the back of your mind. Does that sound familiar? What if that uneasy feeling is not just worry, but a reminder that without a plan, your family's future and your legacy are uncertain. They're not secure. If this sounds like you, if you're ready to find out how to bring peace of mind and avoid legal headaches and make sure that your family's future and legacy are secure, then this episode's for you.
You are listening to the Legacy Talk podcast hosted by James A. Jones,
attorney at law and founder of Sound Legacy Law, PLLC in Tacoma.
Attorney Jones is here to talk about how to best protect your family, assets, and wealth. Pulling stories from his more than 20 years of helping families and business owners protect their assets, create their estate plans, preserve their wealth, and plan for the future. Nobody wants to think about estate planning, but life has a way of sneaking up on you, and at any moment, something unexpected could happen that will leave you regretting not having acted sooner. So join Attorney James A. Jones in the Legacy Talk podcast, and together learn how to plan for your future today and have peace of mind tomorrow.
Welcome to Legacy Talk. I'm your host, James Jones. So on today's show, we're talking about what would happen if you passed away without a will in Washington State. And I wanted to go through this episode and start with a story. The story is about Maria and Tim. Now, Maria came to see me in my office about 2 years ago or so, and she had a big problem on her hands. See, Maria and Tim were together, and Tim died unexpectedly. They had two small children. They were about 3 and 5 at the time. And Tim died out of nowhere. No one was expecting it, and Maria was shocked. Her world was rocked. She didn't know what to do. She had no idea what the way forward was. And she came to me, and we went over the situation. See, Maria and Tim had been together for many years, and Tim was an ambitious guy. He wanted to make sure that he was investing his money. He was working toward building a real estate portfolio. He had a rental property, had a duplex, and he wanted to make sure that his family was secure. Problem was, Tim died without a will. And the reason might be because Tim was 32 years old when he died, and most 32-year-olds aren't thinking about dying, which is understandable. When I was 32, I didn't think about dying either. And so Tim died without a will and left Maria and these two kids without a father and a partner. And Maria had so many questions. Like, what am I supposed to do now? See, Tim was the primary breadwinner in the household. He was the one that dealt with all the finances. It was his income that supported them. He was making the investment decisions, really. And so she didn't know where to start. What do I do with these rental properties? How am I supposed to collect the rent? Tim did all that, right? How am I supposed to make repairs, upkeep? In fact, there was a unit in their duplex where Tim was in the middle of a remodel, and he was doing it all himself because he was kind of a jack of all trades handyman. He sort of had those skills, and he was kind of a sweat equity kind of guy. And so he was working on that remodel in the middle of it and passed away, unfortunately. So she wasn't even sure what to do with that. Only one of the units was bringing in money. The other one was sort of sitting empty, waiting for this remodel to help get finished to hopefully increase the rent. And so those were her questions. What do I do now, right? How do I deal with these properties? Where does Tim's stuff go? Now, the wrinkle to this story is not only did Tim die without a will, Tim and Maria were not legally married. And in Washington State, there's no such thing as common law marriage, so they were not married. All the assets that they had were in Tim's name only. And so that left Maria with a big issue. And really, the only way forward for her was to go through what's called a probate in Washington. Now, probate is basically this. Okay, I'll back up. Probate's a legal process to clear title when someone dies. So assets like houses, bank accounts, things that have your name on them have to have title cleared when someone dies, right? So if someone dies, the simplest way to explain this is when someone dies, they can't sign their name anymore, right? And things with title have the need for a signature. And so probate is the process of getting someone authorized by the court to sign on behalf of someone that's died. And so that's what we had to do. So probate process is long. It's a pain. It's a hassle. Typically, a probate's going to last between 6 to 12 months on average. And so the process is basically, we went to court, we got Maria appointed by the court and authorized as a person called a personal representative or executor. If you hear those words, personal representative or executor, that's basically just the person that's in charge of the probate, right? That's the person that the court says can sign and make this, estate go, okay? So sell property, deal with banks, transfer assets. And in this probate process, there's a lot of legal hoops to jump through. It's a hassle, right? It's also public record. And in this case, the public record aspect of it wasn't great because Tim and Maria weren't married and Tim was such a younger man. His parents thought they'd stick their nose into the situation. They thought they knew better about how to deal with these kids and how to deal with these rental properties. And so that made the probate even that much harder. And it basically, dealt another blow to Maria and okay, you lost your partner, you lost the father of your children, and now you have to deal with this family crap. And so it turns out more often than not, if there's a probate, there's a hassle. And if there's a probate, there's someone unhappy about the probate, or there's someone unhappy about what they would get or not get in this probate. So my rule of thumb is if you can avoid a probate, do it. The other issue that Maria and Tim dealt with here, or I should say Maria because Tim's out of the story at this point, is when you die without a will in Washington, the state law determines what happens to your stuff. Okay? And so under the state law of Washington, all of Tim's stuff was not to go to Maria. And why is that, you say, James? Under state law called the laws of intestacy, intestacy just means I died without a will. And the law says, and these laws are, every state has this set of laws, and they're usually pretty similar. But Washington's basically say if you die without a will and you're married, everything goes to your spouse, as long as it's community property, so property you got acquired together as a married couple. And if you didn't have a spouse, if you were not married, which in this case was with Maria and Tim, they weren't married, and state law, the laws of intestacy, don't say anything about girlfriends or partners or unmarried relations. And so in Tim's case, state law said everything goes to his kids. Now, thankfully, in this situation, Maria and Tim, the only kids that Tim had were the kids that Tim and Maria had together. And so that allowed Maria to take control of the assets for the kids. And so when Tim passed away without a will, the state says, okay, well, we'll give everything to the 3 and the 5-year-old. So what are you supposed to do in that situation? What's supposed to happen there? And so what we had to do in this case was we had to create a trust for these kids, thankfully managed by Maria, who was their mother, to manage those assets until they could be old enough to deal with them themselves, right? And so we had to create this trust out of whole cloth. It took a little bit more procedural time and effort and money to do, but we did it. And ultimately it turned out okay for this family, right? Ultimately it turned out okay because even though they didn't have a will, the kids that were involved were joint kids. And even though they didn't have a will, the probate process allowed Maria to be appointed because she was the mother of the kids, the main beneficiaries, without much of a hassle. But the problem was we still had to create this trust out of whole cloth. We still had issues with outside family, even though they're parents, they're not immediate family necessarily. And so we don't want to have to deal with them, right? We don't want to have to deal with those delays, right? And the burden of the probate was basically jumping through all of those court hoops, right? Jumping through the uncertainty of what's going to happen with your stuff. Being required to tell the world what the estate consisted of. Because in a probate, everything's public record. And Maria was required to prepare an inventory, and that inventory is public. And so the inventory basically shows what the assets were. And so that sort of triggered the parents, I think, to come in and check on this, which really, is a negative situation for sure. So what would have happened, and I guess I'll back up a little bit, okay? So the other thing about this probate is it wasn't the 6 to 12 month probate. It was the 2-year variety of probate. And that means that Maria was living with this probate for 2 years. She was dealing with court and issues in that regard for 2 years. And so it wasn't easy and clean and simple, which is what we're really looking for our families, right? We want to make sure that the plans that we put together for our families are easy and simple and clear, right? But that probate was anything but. So what would have happened? Let's back up on this thing and let's think about like what would have happened? What could they have done differently in this process to have changed what happened, right? What could they have done differently? And it's easy to say, okay, well, retrospectively, Monday morning quarterbacking, well, they should have done a will. And should they have done a will? Yeah, they should have. Did they do one? No. But what would it have looked like had they had that will? Okay, that's really what we're trying to get down to. What would it have looked like if Tim and Maria would have come to see me before Tim died, right? And in reality, there's certain plans that make sense for certain people, right? In a situation where it's a young couple with minor kids, a will plan is pretty suitable in most cases, right? And so let's talk about how we would even do that. So what does it require to get this will done? What could it have done for them? Okay. And so basically to create this will plan involves maybe a couple hours, right? In my case, our setting is basically we would have Tim and Maria come in and meet with them and figure out what makes the most sense for them. So say, let's do a will. Okay. And we would say, okay, well, you've got minor kids. You're not married. Not being married is a major issue because, like I said, the state law says there's no issue or no provision for a girlfriend, right? The law doesn't make any space for a girlfriend to get anything. And so if you're not married, having a will is even more important, particularly if you want your stuff to go to your partner. So let's talk about the structure, though. So really, in reality, if Tim and Maria would have come in to see me or any other estate planning attorney or even done a will online on some form that they found online for free, things would have been night and day different. Because here's what the will would have done, right? The will would have basically said, hey, I've got this stuff. I would have said, basically, I've got this stuff. I've got a house. I've got a duplex. I've got bank accounts. And it would have said, who's my family, right? Who is my family? And in this situation, Maria and Tim would have been family, even though they weren't legally married. They were a family. And we've got these kids, these minor kids, and we want to make sure that they're part of this thing. And so the will would have had provisions for all of that, right? It would have said, if something happened to Tim, everything would go to Maria, most likely, right? They were acting like a married couple. The only thing that they weren't was legally married. So the will probably would have said everything would go to Maria. And it would said, well, what happens if Maria and Tim died together? And the will would typically say when there's minor kids involved, it would say, hey, if there's minor kids involved, we want their share to be held in a trust for their benefit, managed by someone that we trust until they're old enough to do it, right? Because 3 and 5-year-olds can't have assets. They can't put their money on an account or a name on an account. They can't own a bank account without someone's name on it. And so they need to have something in a trust. And who would have managed that trust? They would have thought, well, who's going to manage the money if we're not there? And based on what probably happened with the parents, I doubt it would have been them, right? It might have been a sibling of Tim's or a friend, sibling of Maria's or one of her friends, but it wouldn't have been Tim's parents, that's for sure. And the will also would have said, well, who's in charge of this thing? If Tim dies, who's in charge? The will probably says Maria's in charge. So that means she wouldn't have to jump through as many hoops to get appointed as this personal representative person in charge of the estate. And so that would have been easier, right? The other thing that the will would have had, and this is when they died together, but even if they didn't, it would have had this. It would have say, hey, basically, if I die, speaking for Tim, if I die, I want Maria to be the guardian of the kids, right? Who's going to take care of the kids when I'm gone or if we're both gone? The will would provide that, right? That's something that they would have known, right? It would probably be a friend or family member, probably not his parents, based on past history. And so the will would have had all that stuff in. It wouldn't have required to have a trust made out of whole cloth like we did. It wouldn't have had the requirement of having Maria go through so many hoops to get appointed as the executor. I didn't mention that she had to post a bond to become executor, which is basically like the court saying, hey, you got to back up what you're going to be doing on this by putting some money down to ensure that you're not running off with everything. That's basically what the bond would be. And it's not cheap. It's not free. It's not the worst thing in the world, the most expensive thing in the world, but it's another thing to have to do, another hoop to have to jump through, and another expense to have. Okay. So could this happen to you? That's a good question. The point of all this is, could this happen to you? And how do we make it so that it doesn't, right? Could this happen to you? How do we make it so it doesn't? And so the answer is yes, right? I'm 50 years old. I just turned 50. 50 is the new 30, by the way. We'll take that. But that's my view, at least. Anyway, could this happen to you? Yes, right? We don't ever know when we're going to be leaving this earth, this life. We don't know the answer to that question. If we do know the answer, I don't know how that would change our lives, but it would probably change them significantly. Anyway, if you're thinking about it, right? If this is something that's on your mind, if you're thinking about, well, what would I do if I didn't have a will? What would my family do? What would my spouse do, right? Would he or she be okay, right? Would the kids be okay? And I'm not just talking financially. Like, we think about financial security, right? We think about financial security a lot, and that's important. And it's part of this, right? Financial security and having an estate plan in place that helps direct where that goes is important, right? But the process is basically thinking about, well, okay, who's going to be in charge if we're gone, if I'm gone, or if we're both gone? Who's going to be in charge of our estate? If we have minor kids, who's going to be in charge of their money until they're old enough to be in charge of it themselves? And who's going to watch them? Who's going to be in charge of them personally? And that's the guardian, right? So you need to know 3 people, right? Who would the personal representative or executor be? Who's in charge of the estate? Who's in charge of managing the money for the kids? And who's in charge of the kids personally, like their guardian? Those can be 3 different people. They can be the same person, and I won't get into it today, but there's reasons why you may not want to have them be the same person. I did an episode on this before. You can go find. But if you have the thought in your head, well, let's do this, you should probably just do it, right? The time that it will take to get it done, as far as with an attorney, typically it's maybe 2 hours with an attorney, maybe. You might have some walking around time to think of those people, maybe some discussions between you and your spouse or your partner. And if you're not married, it's even more important that you get this stuff on paper, because you may not know this, but you can't promise things. You can't say, well, I want this to go to Betsy or whatever, right? Like Tim couldn't say, I want everything to go to Maria and it's going to be binding. That's not a verbal comment like that is not something that you can hang your hat on regarding what happens to your estate. So if you are this person that hasn't got their estate plan, this is for you, right? If you know a person that hasn't done their estate, then this is for them, right? So let them know that it's important. Make your life easy, right? Make it clear, make it simpler. Because, estate planning isn't going to change grief, heartache, uncertainty, really, like personal uncertainty. It's not going to take those things away. But what it's going to provide is a way forward. It's going to provide a way to basically have peace of mind that when you're gone, your plan's laid out, right? And that you've put someone in charge of that plan who is competent and willing to take it on and administer it. And so, while it doesn't change the grief and the heartache and all those things, it does make it so much easier and simpler, even if you have to go through a probate. Now, there's other things to do. Right? And a will is better than no will. But sometimes there's better alternatives even than a will, which in many cases is a revocable trust. And so our next episode, we're going to get into more of a discussion as to what the benefits of a will versus a trust are and why we would pick one over the other. So if that's something that interests you, check out our next episode. But for today, if this is something that you're thinking about, or if you know someone that's thinking about this or would benefit from this, have them take a listen. So that's it for today's episode. I'd like to thank you for listening to today's episode of Legacy Talk. If you liked today's episode and would like to learn more, please like and subscribe for more great content. I've been your host, James Jones. To your legacy.
Thank you for listening to the Legacy Talk podcast by attorney James A. Jones. If you found today's episode helpful, we ask that you like and follow us on all major platforms so you don't miss out on the latest episode. If you have questions for Attorney Jones, reach out at info@joneslegacylaw.com or visit our website at joneslegacylaw.com. Join us again next week for another episode of the Legacy Talk podcast.